Hi, y'all, and welcome to tonight's live stream. The state of Indiana paid money to sketch artists to produce 4 sketches of a man identified to be in the area near where 13-year-old Abigail Williams and 14-year-old Libby German were both murdered. They were murdered on February 13th to 14th, but probably the 13th of 2017. Their bodies were found on the 14th. Now, the state believed those sketches might lead to something. They only released 2 of those to the public. But now, having released those pictures to the public and asked the public for help in finding those people, the state is now saying that they want to keep those sketches out of the trial, that they want to prevent the jury from seeing these sketches. The jury won't be allowed to see those in the trial of Richard Allen, which begins tomorrow. Tomorrow will be opening statements, and we will also have the beginning of the state's evidence. We will begin to see how the trial is going to unfold starting tomorrow. But normally, the state is pushing to get sketches in. Normally, the state would want to have those sketches as part of what the jury looks at. After all, they wanted the public to see those sketches. So why now would it be something that they want to keep the jury from seeing? We're going to get into the motions that went on today. Today, the jury was sworn, and the jury has been brought down. I've moved too. You can see I'm in yet another hotel room, and I am now closer to Delphi, where the trial is going to be, in order to make sure they had a jury that knew as little as possible about the case. They found the jury and the jurors in the county, Allen County, where Fort Wayne is. They now have brought those jurors down. Those jurors are going to sit here at the Delphi County, at the county courthouse where Delphi is. Delphi is where the murders happen. So that will all be happening tomorrow. But what I wanted to go over tonight was what happened today. I've said I want to be your eyes and ears in the courtroom because it's not televised. And I think it's super important that there be eyes on the trial. We have a constitutional right to a public trial in our nation. And I think that's really important. And there's been a great deal of difficulty getting information out of this. It literally would have been impossible to cover this trial without being here, because you'd be trying to cover it based on what other people are saying. You'd always be well behind, and you're assuming that they picked up on the very things you thought were important, since it's not televised and people aren't even allowed to have phones or do live tweets or anything like that about this case. So it's just been very difficult, and I wanted to lay eyes on it myself. And so that is why I'm here for a month and moving from hotel room to hotel room. So I did want to give y'all a little story from trial. Each morning we're standing outside in the dark. It doesn't get dark. It doesn't get light until about 8 a.m. here. It's really like 7:51 is sunrise. So we're standing in the dark, and it's freezing cold outside the courthouse. And today I met a woman named Jennifer, who is a middle school teacher. She's a science teacher, and I shout out to Jennifer. She watches the channel, and she came down to the trial because she likes finding real life examples of things for her middle school students when she teaches them science. So she likes to watch any kind of expert testimony or things like that. So I promised to give her the update on what happens with expert testimony at the trial. But isn't that awesome? Can you imagine a middle school teacher who's that committed to making it interesting and exciting for her students? And I said, well, the students must just love that. And she said, oh, middle school students, they don't like anything. That is a really good point. But I will say, shout out to Jennifer, because I think that is totally awesome. I think that is really cool that she does that. So in the chat, give Jennifer some love. Hopefully she's watching. We're also going to get some special inside the courtroom sketches from another woman that I met here. I'll show you those after a little while. So let's get started talking about these sketches, because the whole thing is sketchy, if you will. It's just strange that now the state wants these sketches out, sketches that were put out to the public, sketches the public was told, go look for this person. So what they've put on a witness today, Thomas Plants, who was a retired special agent with the FBI. He was a special agent and forensic artist. He had done 400 sketches for the FBI. He talked about doing cognitive interviewing, where you elicit information from a witness and you take the witness into the context of the moment and you try to get them to remember and communicate the details of what the person looked like to you. So he, in fact, was involved in one of the sketches in this particular case. He talked about sitting beside the person, you work together as a team, talked about my ability to do an interview and my artistic ability. He said those are the two things that are factors in what makes somebody good at this particular job, interviewing and then being able to carry out the art. So he talked about asking a witness to estimate age. Let's just go ahead and, oh no, I don't have my outro in either. Hopefully I can add that someplace along the line. All right, let me share my screen with you. Hopefully I have this. Here we go. Oh, wait, I don't want to give that away. I want to save that for later. Okay. Let's take a look at some of the sketches that were in this case, because there were a lot of different sketches, and it really is a pretty good argument for Richard Allen, the defendant in this case. So did it come up? Yes, it did. Okay. So you can see on the left, I assume I'm not mirror image. So I think on the left, you see an older man, and I will show you a picture. Do I have that one? Let me, oh, I know. We can just show the thumbnail. The thumbnail that I did for this video has a picture of Richard Allen. For sure, Richard Allen doesn't look like that. I'm just going to share a different screen because I really want to show you all that. Sorry, I'm sort of discombobulated. I'm still not in my final hotel room, so I'm just going live from somewhere else. It's all very confusing. So anyway, I'm not fully combobulated. I'm discombobulated. That's what my husband always said. All right, let's see. I want to show you pictures of Richard Allen. I'll show you this and share my screen on that. So this, let me stop that screen and present another screen to you. Window here, share. Okay, so right there you see the picture of Richard Allen in the purple shirt, and you see the two sketches. The first one, the older man, was released first by the police. And you can see where that might look like Richard Allen. It conceivably could. The second one was released later, substantially later, and the police said, stop looking for that other guy we showed you a picture of and instead look for this guy, this younger guy. Well, the problem with that, of course, was that it meant people thought it could not be the older person. And Richard Allen looks, in my opinion, absolutely nothing like the younger guy. I don't see how that could possibly be. There was testimony by one witness at the 3-day hearing in this case that those two pictures you see are the same. And I'll stop that screen, go back to adding my other screen that shows you these two side by side. I just do not see it. Uh-oh. It says stop sharing. And then I guess I have to add another screen. Let's see. It's not working. It's showing up on my screen, but not on yours. Well, give me just a minute and I will see if I can get it back for you. Well, I can always, oh, it says capturing a different screen. Okay. Share screen window. See if that worked. No, I'm going to try one last time and then we're just going to talk because that'll be too boring. All right, let's see what else we can do. I have to tell it that it can't access the screen. Okay. Seems to me that should be clear. All right, let's see. Oh, I really want this to show. So I really hope this works. No, it's not working. That's all right. We'll just talk about it. So ultimately what the state wants to do is keep the jury from seeing any of those sketches at all. Any of the sketches that were out there. Yep, I've got these up on PNG. So I'm gonna at least show you that because I can reach that. Share screen. Okay. No. Okay, I don't know. I could probably leave the studio and come back, but it's just not going to work. So, all right, we're just going to talk about it. There were 4 sketches that were done with 4 different witnesses and done by some different sketch artists. So the state said, we don't want any of those sketches to come in. It will confuse the jury. Obviously, part of the reason is that at least one of the sketches, in fact, 3 of the sketches looked absolutely nothing like Richard Allen. Richard Allen says, well, that's the very reason I want it in evidence because it doesn't look like me. Now, Richard Allen's team is walking kind of a fine line because they want one of the sketches out, the one that looks like Richard Allen. And they say the reason they want that out, and it's a good one, is that the witness wouldn't agree with it, wouldn't say, yeah, that's what the person looked like. She said, no, that sketch just really didn't work. So it does make sense to keep that sketch out. But they want that second younger sketch in evidence, and they want it in evidence because they obviously think it looks unlike Richard Allen. So the state has a pretty interesting argument on that. The state says, look, this is hearsay because it's a sketch by a person sits there and draws a sketch based on what someone else tells them. And that's hearsay because neither of those witnesses are here in front of us, and the sketch is produced from it. It's not an actual piece of evidence. That's a really interesting argument and has some validity, I think, that this is hearsay. But Richard Allen's team says, well, we could put the witness on the stand and the witness could say, yes, that's what the person looked like. And in that case, it becomes a piece of evidence. And these are, in fact, used all over the country all the time. Usually the state admitting the sketch in evidence and the defense often wanting it not admitted in evidence. So in this case, the state wants a hybrid, one in, one out, and the state wants none of them in whatsoever. Now, the older sketch, the witness they put in, the FBI agent, said it's really difficult to get witnesses to talk about age and to estimate age. And the reason is that they just can't estimate ages other than around their own demographics age. Then you can get a pretty good sense of how old the person is. But if you're older and you try to reach younger and try to reach older, you really can't. You won't be able to tell what exactly the person's age is. You're guessing and you'll probably get it wrong, or at least a good chance you will. So the agent was doing that to try to explain why those 2 sketches look so radically different, because they do look radically different. Now, as far as age, he was trying to discredit the idea that the witnesses saw somebody older or saw somebody younger, and to argue that you just can't rely on these sketches. These are not something that ought to come into evidence, which was a surprising argument really from the state and sort of the opposite of what was normally done. Another awkward problem, I thought, with that argument is the people who gave the evidence for these sketches were younger people. So you would think they would have had a pretty good grasp of how old that younger sketch was, because that was very close to their age range. So, but he wasn't asked about that by the defense. I did think that was maybe one issue that they might have asked about that would have been effective. Although I think the judge has ruled against the defense on pretty much everything, and I'm not expecting anything different to happen right here. I'm expecting it to be pretty much the same thing. All right, so the state argued that these sketches were just used for identification, that the reason you do the sketch is to give it out to law enforcement, so law enforcement can have some guidance on where to look and who to look for. But of course, That isn't what happened here. In this case, the police released at least 2 of the sketches to the public and told the public to look for these people. One anecdote I heard standing in line, one of the local press members said that during the period right after the time that the murders were committed, people were sending out the pictures of Bridge Guy. There was a very blurry still shot taken from Libby German's phone in a video she did. And on that still shot, the man is walking rather quickly. You can see him walking, but he's got his head down and you can't really see his face all that well. You can get a little hint of it, but that's really about it. And a little hint about the size. So people were putting pictures of locals side by side with Bridge Guy. And many people were being put side by side with Bridge Guy. And in this particular, the newspaper guy, reporter said, I was really worried. I told my wife, well, anytime now they're going to put out a picture of me next to Bridge Guy and say that I look like Bridge Guy. So I think that there was a lot of that. A lot of people were really looking hard at that image. And then, of course, at the sketches that were sent out to see whether or not they could help law enforcement find the killers of Libby and Abby. So, and I had many fewer notes today since it was just motions. I had 23 pages of notes today. All right. The witness argued that those sketches ought to be looked at as just sort of an approximation. This wasn't something that was meant to be exact. It was meant to just sort of approximate what the person looked like. And he even said that when he does a sketch, he pretty much intentionally makes it a little more, this will be my word, cartoon-like or sketch-like, because he doesn't want to make it overly realistic to lock people into one view, because that isn't really what he's doing. Now, the defense argued that these are routinely admitted and said, and also started to go after the witness on the way he developed his own sketch in this case with one of the witnesses. And what they said was that he spoke with Sarah Carbaugh. Now, he produced the older person image that I showed you. And he spoke with her back on June 19th, 2017, which was about 4 months after the murders had occurred. And he had stated in his direct testimony that you needed to wait, let the witness unload all of their understandings, their memories about what happened in your interview. Then you ask them some more questions and then you begin the drawing. So there's some time and then you spend time doing it. So she started to ask the question, the defense lawyer, within 4 minutes of starting the interview, and there was an objection right then and there. And the objection from the state was, look, I didn't ask about any one sketch or didn't move to keep out one sketch. I moved to keep out all of them in general. So the questions ought to be limited to the scope of what I was talking about. What I was talking about was that the sketches in general shouldn't come in. So it doesn't matter if he messed up on one. None of that is relevant at all. So we didn't really get an answer on that. And I was frustrated with that, as were the people sitting around me. I was really curious what exactly it sounded like. The question was going to be, within 4 minutes of starting the interview, you began doing a sketch, suggesting he didn't follow his own protocol. And then the defense also talked about the fact that the best practices from a group he himself belongs to and has spoken to in seminars, that the best practices say a witness may be instructed that her description may be used to ID someone in court, and once documented is to be perceived as a piece of evidence. So they're suggesting, the defense is, it's normal to put these in evidence, and you warn witnesses that's what it's for. So why is it being kept out here? All right. So then there was also a question, and this came out pretty well for the defense. You would never tell a witness it was okay to cheat, right? He said, well, I use the phrase cheat code sometimes as a way to get additional information. Like we could use a cheat code, meaning we could figure out a way to get additional information. And the defense said, well, you told Sarah Carbaugh that it was okay to cheat, didn't you? And he said, I don't recall that. So she played a clip from the interview in which the witness said, we can cheat. I do this all the time. We can cheat, and we don't have to make this hard. And she said, I assume it was audio only. We weren't seeing anything. We were only hearing audio. And she said, you were cheating by showing Sarah Carbaugh the photo, weren't you? Good grief. Sorry. And he said, no, what I'm saying is I asked her if she had seen the image, and she said she had seen it numerous times. So it wasn't clear, and I don't know that there's any kind of video to capture that, but they were suggesting that he had breached his own rules that you never ever show a photograph, that's something that you're never supposed to do when you're making a sketch with a witness. He argued that there was no problem with showing the bridge guy photo, the blurry guy walking on the bridge, because it doesn't really show the face. So it wouldn't prejudice somebody when it came to describing what the face looked like. The witness said, if you do a surveillance video where a face isn't visible, then that's often used to trigger a witness remembering, and that would be okay. That would be totally fine. Now, the defense said, well, there's a partial face, right? I'm sorry, just a second. Okay, maybe that will help. All right. Then they talked about the deposition of Betsy Blair, who did the younger sketch. And she said this was the man on the bridge and gave it a 10 out of 10. This is exactly what the guy looked like. And they said that means the younger guy, that one's a lot more likely. There wasn't a testy exchange between the judge and the defense witness where the judge said, do you have case law? And because she was reading some, the defense lawyer, it was Auger, said yes. And the judge said, well, did you not supply it to me beforehand? And the defense lawyer said, well, we just got the motion on Tuesday, so I haven't even filed a written response, but I have them here. All right. I don't want to stop in the middle of that, but I don't want to forget to give you this. I'll go 2 more pages and then remind me to come back in the chat. The witness did testify and adopted in court and made it non-hearsay. That was what the state said ought to be the touchstone when there was an adoption of it in court. But they believed there had not been that here, wouldn't be that here. And that was when the defense pointed out that it wants that older guy sketch to be eliminated. I do think that's a hard position to maintain, to say, well, this sketch out, that sketch in. It's easier to say all the sketches in. One of the arguments that the defense could have made that they didn't, at least I thought it would have been a good argument, is the reason that those sketches are so important is because they show sort of a chaos within the law enforcement search for whoever had murdered Libby and Abby. It was an older guy. No, it was a younger guy. Could be this guy. Could be that guy. The reason that's important is one of Richard Allen's strong arguments is that the investigation looked in many different directions, that the investigators themselves weren't really sure what the person looked like. They considered numerous other suspects. And for that reason, the investigation itself was fundamentally flawed and failed to look in some of the correct directions. That would be a reasonable argument that a defendant would often make. So in this particular case, they didn't raise that. And I think the reason was because they really want that older guy sketch out. I think the result is probably going to be that the judge keeps both sketches out and says the witnesses can come in and talk about what they saw, but there are not going to be any sketches. That's what I would be willing to bet. She took it under advisement, so we don't know for sure. But I think that's in the end what the judge will do. She's really almost never gone with the defense. So I think that that's probably not going to happen. All right. So we did get to see our jury because they were sworn in. So there was some confusion because we added an extra juror at the end of the day when we thought that the jury was full on Tuesday. So they brought in another panel and added yet one more juror. So we weren't really sure exactly who was on the jury and who wasn't. It looked like probably they had lost another member of the jury. So in the end, we have 8 women and 4 men on the jury. And then the alternates are first chair and second chair are 2 females, and third chair and fourth chair are 2 males. It is 100% white. There are nobody of color on the jury. That frankly is not way off from what the jury pool was. There were not very many people in the entire pool. So that answers the questions that people had asked me. We now know a little bit more about who the jury will be. All right. The state wants to have 2 witnesses, and I better say thanks to some people. Oh, we have some new members, Crown Bird and Lee T. Fantastic to have you. And thank you, Lee. I really appreciate that. That's very nice. Thank you. So the state wants to have 2 witnesses present. Now, what is this all about? Normally, if one side or the other moves for what I have always called sequestration, but what they are calling separation of the witnesses, you keep the witnesses out of the courtroom while everyone else is hearing the testimony. That way they don't hear the testimony of other people and they can make their own decisions. They can make when they answer questions, they aren't influenced in any way by what anybody else has said. They have to, only after they've completed their testimony can they sit in on the trial and listen to it like the rest of the public can, or in some cases, the rest of the public can. But in this particular case, the state wanted not, and let me back up. Often each party will be given one sort of freebie where somebody can sit in all the way through. The state usually wants that because they'll have a lead investigator or someone doing coordination of all the witnesses. And that person may well know about the case and be involved and be going to testify, but they are also going to do all the organization and bringing in witnesses. So they need to actually be present so they know when it's time to get a new witness. But the state wanted 2. They wanted 2 of the key investigators, Holman and Mullins, to both be there. And the court granted that. The defense said, well, that we don't want them talking or knowing about what the witnesses ahead of them say or what they themselves say on the stand. But the court granted that and gave the state two people who would be allowed to not be sequestered or separated and who could watch the entire trial. The defendants asked for a motion in limine, which would keep out evidence in this case. The state wants to put in testimony from prison guards, inmates, and the Department of Corrections staff. And all of those people, and they named numerous people, were interviewed. And in those interviews, apparently, Holman, you just heard about it, he'll be sitting through the entire trial, as well as some others. They had kind of a template, and they asked the witnesses, I understand you don't have any background in mental health, but what was your opinion about whether Richard Allen's actions were genuine? And the defense argued, here's what they're trying to do, Judge. They're trying to get to position things so that they know that the medical personnel from the jail are going to come in and say that Richard Allen was impaired, that he had to take medication. They'd given him medication even against his will, just something that he had to do, was required to take. And they'd given him that. He was in bad shape. They saw him degrading in terms of his mental status, and they were watching this happen. Now, these are actual experts in the field, the defense argued. All these other people, like other inmates, prison guards, Department of Correction staff, those people, they said they're not experts, and yet they are being brought in to say whether or not they're going to talk about, I imagine, anyway, I suspect, confessions that they heard him make, or maybe also about odd behaviors, because we've heard he did some pretty crazy things like eat feces, his own feces, write on the walls with feces, just some really crazy stuff. And they're going to give an opinion about whether or not his actions during this period were genuine. In other words, was he faking him? And the defense was saying, we've got real experts to answer that, real experts who were treating him at the time. We don't need inmates and officers to, inmates and corrections officers to come in and do that for us. The state argued, look, these are the officers in particular. They really didn't talk a lot about the inmates in this, but are skilled witnesses with experience. They're not going to testify about his intent or allegations against him. And the defendant said, well, you are bringing them to say that he said things that were incriminating, and then to say that he was faking or telling the truth. You're asking him to do that. And that is asking him them to testify about whether or not they believed he was guilty or innocent. They're saying, you can spin it, but the fact that he's confessing, and they're going to say whether they believed him and whether he was making sense at the time, that means you've opened it up so that really what they're saying is they believe him when he says he was guilty. That's what they're going to come in and say. And that's more or less the whole point. So the judge said, is ruling with the state on this, that they can testify to their observations of Richard Allen. They can testify to his behavior, to what he was doing and when, but they can't say, I think he's guilty or I think he's innocent. So ultimately what that means is that the state won that and the defense lost. Let me say thank you to a few more people. Chico Karen, thank you. A warm hat. Yes, that is going to be very, very important. I definitely need that. Thank you, Chico Karen. And Janet stuttered. I appreciate the super sticker. Marissa, yes, I'm happy to be here. I'm enjoying my time here, and it's been very interesting. And I've loved meeting all the people here. I've met so many people. It's been a lot of fun. I'm going to be so bummed that I can't show you that. This person has been like doing sketches inside the courtroom, and I thought it was really cool. I thought it kind of looked like him. Looked like Richard Allen, this one. So I really want to show you that, but I don't think I'm going to be able to. I am not sure what happened on that. I'm wondering if there's any. No, that won't work. I'll try it again just for fun. No, it's not working. Okay. I don't know what happened. Anyway, I would have loved to have shown you that sketch, and we'll get it working tomorrow. So tomorrow you'll be able to see the courtroom sketch of Richard Allen, and I'll tell you about how I got it and all that. Okay, so next motion was related to a settlement, the IPA Settlement, and they might have called it the IPA Settlement. I can't remember for sure, but essentially there was a suit, and it was related to the conditions around mental health of prisoners, and said that especially and including when they were kept in isolation. And out of that came some agreements by the state of Indiana that we're not going to do this or that anymore. We're going to make sure prisoners aren't kept. One of the things that we know that the court case alleged was that keeping people in isolation for more than 30 days is very damaging to mental health. And of course, Richard Allen had been in isolation for 4 months when he began confessing. And the defense argues that is what prompted him to confess. That's the entire reason that it happened. So the defense wanted to put in a very detailed definition of serious mental illness that came in connection with this lawsuit. The reason that's important is they say Richard Allen went into the prison with a serious mental illness of major depressive disorder, and that coupled with the way he was treated meant he degraded very badly in jail. They say that led to his series of 61 different confessions. He didn't confess before, then he was treated really badly, confessed, and then he didn't confess after they stopped treating him badly. That's the defense argument. And that's how they're going to explain the 61 confessions. So they want as much in as possible about serious mental illness, about how his own needs, his own mental health might have been part of why he reacted in the way he did by confessing. And in this particular case, the defendant said, we want to put in this detailed description, detailed definition of serious mental illness to show exactly the people who shouldn't have been treated the way Richard Allen was treated. So the judge said, mentioned that this was another comment made, said to the defense, the issue you keep harping about. And I thought that was an interesting way for the judge to put it. The judge, I'm pretty sure the judge took this one under advisement. I don't think the judge ruled. Oh, no, judge ruled. It was not relevant to whether Allen did what he is alleged to do. You can educate them within the policy. So what the state had argued is, you don't really need this lawsuit. The lawsuit's over, and as a result, and out of it came this policy. And you can look at the policy. Sure, it's not as detailed, but you can go to the policy, and that's good enough. So, and the judge said, yep, that's good enough. Now, the final motion of the day related to a witness named Tobin that the defense wants. Tobin is a metallurgist. The state, probably the most important piece of evidence other than the confessions, is a bullet casing found at the scene, apparently in the dirt between the bodies of Libby and Abby. The casing, according to the state and to a state expert, matches a gun they found at Richard Allen's house. That's one of the reasons Richard Allen's team worked so hard to invalidate the search warrant and to say that the search of his home was invalid. But the judge has denied that and said the search was valid. The gun is coming in. And this expert for the state connects the two and says the markings on this casing came directly from the gun at Richard Allen's home. They have one witness who will say, no, they don't. It didn't come from the same gun. You've seen it wrong. You've looked at it wrong. You're just incorrect about that. But this guy Tobin was going to do something different. The whole concept of matching casings to a gun has been very controversial. There are many people who think this is what is called in the courts junk science. There's just no real reason to connect the two. That's not valid. It's not like a fingerprint. These are machine made. And so they will be exactly the same. The variance will be tiny unless a gun has been used substantially for a long period of time. They're all going to come out exactly the same. The casings fired from every one will look exactly like all the others. So this guy Tobin was going to talk about the fact, and he hasn't been ruled out yet, was going to talk about the fact that this is a controversial area of expertise, that the idea, the very concept of matching these things is controversial. So the jury shouldn't just accept. It's not really a battle between the experts who say it was or it did or didn't match. It's really a battle about whether it even matters, whether it's even a real thing. And that's what Tobin was going to talk about. The state said, well, he's not been trained in identification of firearms, which is somewhat beside the point, since what he's saying is that it should never be done. It's not really possible to compare the two. And the state said, well, that would mean no firearms expert could testify, which is in fact what some people think should happen. There is true controversy over that issue. And then let's see if I have anything more on this. I did feel like the defense, I think I'm about through. I did feel like the defense kind of missed an opportunity there, because I think that one of the things he should have talked about was the fact that as a metallurgist, he can say that, I mean, I assume he knows this, or could say this, that he knows that the machine tooling that they do creates metal in a very uniform fashion, or he knows that some detailed explanation of whatever his information is that makes him believe that you can't take a machine-made gun and a casing and say there were unique marks on it. This isn't like a fingerprint. This isn't like a human. This is machine made, and they're going to be very, very similar. Tiny differences. It's going to be very hard to distinguish them. So he didn't really, they didn't make that argument. I think they were caught a little flat-footed because this was a last-minute motion. The judge did take that one under advisement, and we'll just see how she rules. Like I say, she has ruled in general against the defense pretty much most of the time. There was also discussion about some new witnesses the state said they did not have information about, one of which was apparently disclosed in April 2024, which was a motorcycle gang member. So that was highly intriguing. What was that about? And then two were related to Celebrite data dumps that have been given in August of this year, 22nd to 23rd. For some reason, this Celebrite data was pulled from Libby's phone, but not until late, like August of 2024. Given that the murders were in 2017, that's a surprise. But the state had said that one of the things it wanted to do was take a look at using at her data, using new iterations of Celebrite that had come out. It was now better and improved. The judge has allowed the defense to incorporate that 3 days of testimony that happened earlier this summer, and they don't have to redo any of that testimony. They can just put on new witnesses. This is related to the third-party culprits. One of the things Richard Allen wanted to do was argue to the jury that there were plenty of other suspects, people who might have been involved in the case, people who looked like they well could have been, and wanted to put on evidence about that. And it is a right that a defendant can point the finger to other people and say, you did it, I didn't do it. And in this particular case, though, the judge said that he didn't have strong enough evidence to permit him to do that. So all of that third-party culprit evidence has been kept out, and he won't be able to point the finger to other people who might have committed the crime. He can only answer as to whether he did it. In this particular case, the court has said there was testimony for 3 days, or at least for some of the days during the 3-day hearing, that related to this issue. The court has said you can just count that, and you can bring anyone else you want to bring who will provide new and additional information. But all of that is going to be done privately. It's going to be done without the jury being present. I mean, hopefully when I say privately, I don't mean without the spectators. I think the public will be allowed to attend it, but it will not be seen or heard by the jury. They won't have any of that information when they make their defense. The reason that you make a proffer like that is so that when the case goes up on appeal, the appellate court has a full and complete record and can know exactly what that was about. All right, so that is it for what I have, but I'll answer some questions now. I'm looking through to see one other funny story. The first couple of days, we were talking about it. We got it was misty, and we got kind of wet one morning, and the next morning we got misty. It got misty, and we got wet again. Somebody's like, it's so odd that it seems to rain at the exact same time here in Allen County every morning. And then we realized it was sprinklers. There were sprinklers going off around, and that was why it was all misty. All right, so let's see. Where was I on thanking people? I was at Marissa, so thank you, Shelly F. I appreciate that. Josh the Posh 63 is a new member. Glad to have you. Bryn, thank you for the super chat. Rosie, appreciate that very much. And Sue Candle has been a member for 7 months and is hailing from France. Hello from France. Good to have you, Sue. We are glad to have you on board. Thanks for watching from France. All right. Let us take a look. Yes, question marks at the beginning. Yes, thank you for saying that. And I'll start. I may or may not have gone far enough back. Here's Gaming and Sleuthing asking me, can refusing to let him use third-party defense be a reason that this case gets overturned in appeals? I think it is likely to be the number one reason that could overturn it on appeal. I think it's a mistake to keep that out. I've said that. I'm being pretty open about that. I think it makes it ever so much more likely that the case will have to be retried, which is in nobody's interest. And I'm fear that that's exactly what's going to happen. But at this stage, one of the issues might be whether or not they have an argument that it was harmless error because of the fact that there was strong evidence otherwise, such as the 61 confessions. Those confessions are going to be so important. I'm going to listen intently. I wish I could record them. I wish I could play them for you. I'm not going to be able to do that, but I am going to listen intently and try to tell you anything I can hear and give you my assessment of what his demeanor seemed like. Did he seem crazed? Did he seem like he really meant it? Are they making sense? Does he, in fact, confess to details of the crime that only the criminal would know? And if so, did he do that only after he received photographs of the crime scene from his attorneys? Or did he mention crazy things that didn't really happen, such as what the defense has said, his claims that he killed his grandchildren? He doesn't even have grandchildren, so that's doubly not true. So I think, yes, that's a huge issue. Thank you for that question. And Maria, how is the Diet Coke withdrawal going? Maria C. I had a chance to sort of, I guess, get extra yesterday since we did have that day off, but I am back down to a small amount today. So I'm really working on it. Although Lily doesn't think I should. She says Diet Coke is just too good. Don't do it. Lizzie D. Can judge hear the proper evidence and change her mind and allow it in? So, and love the channel from California. Thank you, Lizzie D. Yes, the judge could, but she has given no indication that she would. Instead, she ruled the evidence out. I mean, clearly ruled the evidence out and said, but you can give a proffer if you want. So I don't think she will. It's a possibility. One reason for doing a proffer sometimes is to show the judge what the evidence would be so that the judge can make a decision. In this case, though, she's already announced her decision, and I don't think she's open to changing her mind. Although, who knows? Maybe we'll be surprised. Oh, thank you, Marine, offering a hat and gloves. I actually did buy a hat and gloves yesterday because I realized this was going to be pretty darn important. Rosie McCrank is asking about bucket list things in Indiana. That is such a good question because I am trying to do some bucket list things this year. And one was going to the Grand Canyon. That was huge. I'd always wanted to do that and had never been. So let me put this to our Indiana folks. Is there something in Indiana that you really think is like a bucket list item? I need to go do that thing here in Indiana. So let me know. By the way, if you are local, we are going to have a meet and greet. So please reach out to me. You can find my email underneath the channel information. If you go to the Lawyer Lee channel on YouTube, you can find how to reach out to me. And reach out to me. Let's get together. We're going to have a meet and greet, maybe a lunch or something. I don't know what we'll do, but somehow we'll all get together and I'd love to meet you. Also, if you're at trial, please come say hello. I would definitely like to talk to folks. Gaming and Sleuthing, can the defendant do an interlocutory appeal on this decision? The judge denied their request to do an interlocutory appeal. Sarah, if it gets retried, is it retried in the same court and same judge? I guess that's maybe yet to be decided. Judge Gull was specially appointed. Normally, it would be sent back to the exact same court and the exact same judge. That is normally what happens. But with it being reversed, now the judge is supposed to do whatever the reversal issue was differently. But in this case, given that she was specially appointed, I don't know exactly how the court would handle that. Would they appoint someone else also specially? I don't know. I can't answer that. All right.
Could you try again?
Siri, I don't need to hear from you. So Susan Moore is asking, I'm a bit confused about the sketches, in or out. Answer is not decided yet. Judge is going to rule and we will find out later. It was somewhat of a difficulty. One of the state's arguments was we don't want them using the sketches in opening. I don't know if they planned to, but by not ruling until sometime tomorrow, effectively, they really can't use the sketches in opening. So that, because you just can't really organize your opening with evidence that you don't know is going to come in. It just is too complicated. All right. Lucy asking, how much public interest has there been to attend the trial so far? Has it been difficult to get in? It has been. There have definitely been a lot of people here. The media is covering it heavily. I drove by the new courthouse this afternoon and there were trucks all around it, media trucks and their TV cameras. I've gotten to meet a lot of the people locally who have covered it, and it's so interesting. Many of them have covered the case for years and years. One I talked to today actually covered the case starting the night that the girls disappeared. Somehow the producer said, yeah, go up and cover this. He's like, are you sure? They've only been gone a few hours. Are you sure? And he's like, I don't know, just have a feeling, go. And she went up and she got some of the very first interviews. So it's really cool to meet her. Her name is Emily. She works for WTHR. All right. Can you like twice? Oh, please do. 1971-ish. Vote twice on the like button. Oh, I forgot to say, please hit the like button and also subscribe. We would love to have you back. Lizzie D asking about the profer evidence. Denise, are opening statements tomorrow? Yes, they are. Oh, I'm really hoping I get in. That is really up for grabs, right? And did I cheat? No, cheat at what, Angelique? I don't know. Are you referring maybe to the witness's question? Anyway, Jill Argos, can Gold get disciplined about her bias in this trial compromising Richard Allen's rights? I don't think that there's been any suggestion of that at this time. And 3 times now, the defense has tried to get her removed from the case. And 3 times they have failed and been told in no uncertain terms, no, we are not taking her off the case. So I don't think that's very likely. I don't think that would be an issue. Looking for the question marks at the beginning. Here we go. I think I've got somebody over here. Okay. So Jet Wilson asking me, have you been able to watch him walk without shackles? No, he's not done any substantial walking without shackles. I mean, he stands up or sits down, but really that's about the extent of it. They do remove the handcuffs from his hands. One of the jurors talked about how different he looked. She had seen the photographs beforehand or videos of him. He was shackled really just all over, and he looked very dangerous. He was wearing a big suit as well as the bright color, and he was surrounded by guards. And that they have in the courtroom 2 people in plain clothes who are guarding him, and they're just in a suit and milling around. They don't appear to be guards other than, they bring him in and bring him out, and then they remove the handcuffs from his hands. So he doesn't really appear like a prisoner. They may well have some kind of shock device on him, and that may be as a safety protocol but it's not something that the jury sees. So there's nothing visible that makes him look like a prisoner. That's one of the things that defense lawyers always request, because of the fact that looking like a criminal is not a good thing when you are on trial for a crime. All right, Sue, thank you. I appreciate that very much. I may have skipped. Oh, here we go. Dr. Vonda K, what time are you getting in line in the morning? I don't know. I don't know. I've been debating that all day long. I've been trying to get anybody to tell me what their plan is, and no one is revealing. So I don't know. I think it's going to have to be pretty early. It's certainly not going to be, 7:55 rolling to the court at 8, but I really don't have a sense of that. One issue is no one's totally sure how many seats will be available to the public. We know how many are blocked off for the media, 12, or how many are blocked off for the victims' families or for the defense. But what we don't know is what does that leave left over? And so that's what we'll be aiming for, is to get in and to see the trial. I certainly hope I can, because I've come a long way for this. I definitely want to be able to bring it to you. All right. Well, we'll stop there for tonight. And I wish I could play our outro for you, but I'm not going to be able to. Well, wait a sec. Let me go over here and see, is there any one other question that I need to answer? Okay. What are the jury demographics? So it's 8 women, 4 men, 100% white. That is the answer to that question. And that's just the jury. The alternates are 2 women and 2 men, also 100% white. So looking for questions, not seeing it. Does he look better today? Yes, I did think he looked better today. I don't know if it was what the deal was, but I thought he looked better today. He doesn't seem heavily engaged. You see witnesses who are heavily engaged and they're talking to their lawyers a lot. They're scribbling notes and handing it back and forth. That's not Richard Allen. He pretty much just, looks on and takes it in. He's not someone who is actively involved in what the lawyer should be doing. It's nothing like that is going on. When his opening is tomorrow morning. Tomorrow morning. So does he look? Yes, he looks better. And is this courthouse bigger? So no, from everything I understand, it's smaller. Now, the reason why that might not be as big a deal as you might think is because of the fact that, and I'm opening up my outro as I do this. So give me just a minute. But the reason why that might not be as big a deal as you think is because in the courtroom, when we did jury selection, a huge part of the courtroom was blocked off for the jurors to sit or for overflow as a middle aisle buffer. And then for the media over here, media and spectators of any type. So that there were only 25 seats total, for 5 for media and then 20 for the public to sit in on the trial. Other than that, it was all reserved for jurors. So that's not going to be needed. That's not going to be something that has to be there. So I don't think that there won't be that issue, but the whole courtroom itself, I've heard it's pretty small. It's really pretty different. I've also heard there are super hard benches, completely stark wood, absolutely hard to sit on benches. So we will find out. So Dodd's Discussions asks about Richard Allen's family going to court. They have been to court at every hearing. They have been steadfast standing behind him. I haven't seen them present in the courtroom, but it is really hard for me to see that area. I don't know if they've been in the courtroom during jury selection. That might not be something they would normally attend, but I would expect them to probably be at the trial just based on how they've done in the past. So thanks everybody for watching. I will go live again tomorrow night and tell you what happened, which hopefully will involve me having actually attended the trial. And so I'll go live. I don't know exactly what time it will be. Times are just frankly off because of the fact that I'm having to travel to and from the courtroom. I'm having to go through notes and stuff. I'm a big note taker, so there's a lot to go through. So I will continue to do that, and I look forward to seeing you tomorrow night. So thank you everybody for watching.